there's been so much in the news lately about obviously this trade war, and it seems to change every day. So it's hard to get a handle on it, and especially hard as a startup to know what to do, how it's going to affect your company, how you should be thinking about your supply chain. A lot of our supply chain and hardware necessarily has to come from overseas. It's just not cost competitive to do it here in the US. So we are going to get all the insights and the latest information from our Fireside Chat guests here tonight. So before we get started, we'd like to introduce Mark Cohen and Phil Rogers. And you guys want to take a minute to let them know about all your expertise here?
Sure. So my name is Mark Cohen. I teach at Berkeley Law. I teach international trade. I teach Chinese intellectual property law. I actually, in addition to being an IP lawyer, before that I was a trade lawyer doing customs and other related stuff. So this is a unique moment in time for me where both those disciplines have come into play. In fact, I was in the Trump administration at the beginning of the trade war and was actually given a medal by the president for my work on forced technology transfer. So coming in?
Yeah.
I was.
Hello. So my name is Philip Rogers. I am a PhD candidate in political science at the University of California, Berkeley. So this is a very exciting opportunity to talk to you all because in many ways I look at this conference as a confluence of many of my interests. So I got a degree in economics, I got a degree in public policy, I then worked as a paralegal at a Chinese law firm for several years in China. So I studied innovation in China, state business relations in China. So many of these issues are a confluence of all my academic and professional interests. So thank you for having me.
Okay, thank you guys. So it's just so hard to know what is happening on a day-to-day basis and how things are changing. You hear news from the White House one day, you hear the almost opposite news from China seemingly the next day. So why don't we start with maybe a starting point? Where are we? Can you give us kind of the up-to-date information?
Okay, so first of all, we aren't where we appear to be. President Trump seems to be following the stock market more than the reality of the negotiations. The original basis, if you want to dial this back, for this trade war was about our view that China was engaging in forced technology transfer, which meant that China was engaging in cyber intrusions into U.S. websites, compelling U.S. companies to transfer technology as a condition of investment, had a weak IP system, was investing in U.S. companies to acquire the technology and take it out, and also some other nefarious activities. Most of the legal issues that we asked for in the March 2018 report on that topic, surprisingly, were given to us by China. You don't read about that in the press. We asked China to change its technology transfer law. It was changed. We asked China to change its foreign investment law. It was changed. And a range of other laws were also changed, including their trade secret law. The president, who likes to seize victory out of any defeat, in this case wants defeat out of victory. It's a very un-Trump-like moment. Now, what he does seem to like, though, are tariffs, and he seems to be very concerned about soybean farmers. So we've had a round of tariffs, we've had a round of counter-sanctions, because after we retaliated against China, then China retaliated against soybeans and other products, then we counter-retaliate, so we start imposing, whether it's 10%, 25%, or other tariffs, based on the current situation. Again, if we dialed back about a year ago, the president is speaking to U.S. Trade Representative Lighthizer, and he's saying, I don't want a memorandum of agreement with China. I want a real agreement, as if he wants something that is really, cast in stone to deal with both the legal issues and what he viewed as the structural issues of the Chinese economy. Well, the last meeting with Liu He, the Chinese principal delegate, he seemed to be willing to take a handshake and tell the stock markets that, gee, we got this resolved or almost resolved. Now it looks like a phase 1 agreement. Maybe that will be in December. They're not going to be in Chile. It's a little bit unclear what will be in that agreement because I think we'll see soybeans almost certainly. How he'll handle these issues that China already delivered. In fact, the U.S. brought a WTO case against China, and we withdrew it. Doesn't appear in the papers, but we suspended that case because we were satisfied with China's commitments. So we're at a very odd moment in time where it seems to me that he's manipulating the outcomes to try to get the maximum advantage that he can for the election, for the farmers, and that he's also injected a high degree of unpredictability into tariffs. And I think I'll let Phil fill in on the tariff side.
Sure, yeah, so I mean, just coming from a wonky political scientist side of things, right, there's this thing called the Thucydides trap. That is to say, throughout history, when you have two great powers, there's not enough room for both of them. You have a rising power, you have a great power, and they're going to compete with one another at some point. So, in many ways, one could look at that what's happening now rather than guns is happening there. So a lot of people like to cite World War I as a counterexample to, well, you're all Lincoln economically, you're not going to have a war. But the thing to keep in mind in World War I, when we were looking at Germany and Great Britain, was the fact that many of the goods were actually produced all like within the country. We didn't have the sort of supply chains that we have today. So with the economic integration, who knows? So, the whole situation makes me think of this Coke ad they had back in 2008 when the Olympics was playing. I don't know if you remember it or not. It had Yao Ming and LeBron James. It was this computer animated, lovely thing where they're like scowling at one another, and like LeBron James pulls out a cowboy, and Yao Ming pulls out like a dragon, and they keep pulling out all these like cultural tropes, and then they will pull out a Coke bottle, right? And when they pull out the Coke bottle, all of a sudden they start smiling at one another, and it's like, oh yeah, and cheers, right? So we've thought for a long time that trade can be this like thing that links us together. We can scowl each other for a long time, but then we pull out the Coke bottle and blink, right? But when you get into the tariffs, you really are getting into hardcore constituencies, right? Things like soybean farmers, things like you all, right? Things of that nature. And when we look at the tariff specifically, it's not affected all industries equal, to be sure. It's really hit very, very hard telecom. It's really hit very hard office machinery. That's where pain is really being pinched. Now, people like to ask, can this trade war be won? Will the trade war end? Things of that nature. And some of it depends on what your scopes are, right? What your scope conditions are, what your definitions of winning and being over are. It's important to keep in mind that Xi Jinping has constituencies just like Donald Trump has constituencies, right? So, tit for tat's very important. You can rally around the flag, right? And get the Chinese people to believe in a sense that he's standing up to the Americans, right? That's helpful for him in a sense. So right now, it is a very interesting time, right? Because China just happened to get hit by swine fever, right? So a lot of hogs that are often used for pork did not make it, right? So you can't use that for food supply. So that is kind of a leverage point, as it were, in the trade negotiations at this point in time, perhaps. And you also have the holiday season coming up. Again, constituents are important. Donald Trump doesn't want to ostracize everybody, so there have been some relaxations on some electronics and things like that. But December 15th is kind of this magical deadline when tariffs will kick back into play. So will this leveraging in terms of these key points at this particular moment in time, economically, will they lead to anything? They might lead to some phase 1, but then what, right? So my own personal view of the trade war is that we'll see a lot of what we've seen throughout Sino-American relations for a long time. You'll see a lot of growling, and then there will be a moment in time where you'll have a ceremony and make it look like something's happening. And meanwhile, people like you will go about doing business, right? I mean, Donald Trump and Xi Jinping are guys in suits, right? But we have to move on. We have to move on with the world.
I might add here something else which may be important for this audience, which is that when we look at what has been disrupted in terms of the tariff line or the standard industrial classification code, we find, just as Phil mentioned, a lot of them are in high tech, in telecom, and office machinery and scientific equipment. Now, many of those products are also products that are manufactured over extensive supply chains. And we can say that two goals, and this is evident from what Trump has excluded from the tariffs, two goals are that if the product is available from outside of China, then he wants to impose tariffs on it. Because he wants to drive manufacturing of that product outside of China. So we've seen an uptake in exports from Taiwan, for example, to the United States. And some modest uptake in other markets, although I think China is a very difficult manufacturing base to replace. But if it's available from elsewhere, then some of the big OEMs, like your Foxconn's, Qantas, are looking actively at manufacturing outside of China, at least to provide more stability into the U.S. market. The second thing, and again, this is based on the exceptions to the tariffs, is that if it's within the categories of technology that are enumerated in the Made in China 2025 plan, which was this plan that the U.S. government viewed as threatening to U.S. industry, particularly high-tech industry, then he is also more likely to impose tariffs on those goods. Now, is that going to go away with a Phase 1 deal? I actually think not, because I think what this administration is saying is that as long as Trump is in charge, he would like to see a decoupling to some degree of the U.S. from China. And if it's something that can be sourced from elsewhere, then he'd like those jobs to go elsewhere, ideally to the U.S., but if not that, he'll take a Taiwan and India, a Thailand and Vietnam, etc. So if you're in that space where products can be sourced elsewhere, and it's somewhere on that Made in China 2025 list or a high-tech area of concern, then you're in a position of potential vulnerability. Let me flip this one step further, though, because there's another thing that we see when we look at what has been excluded, what has been hit, the reasons for the trade war, is that there's also an overlap. People really are not talking about this so much, but it's almost intuitively makes sense between those products that are in an extensive supply chain, typically many countries or many factories, if it's all coming out of one city or one country like China, are also products that frequently have a high degree of IP intensivity to it. That is, there's a lot of technology around it. A lot of it may be proprietary, some of it may be patented. Phil and I looked at this specifically using some UN data, and we found there was a high degree of correspondence between what I would call supply chain intensive products and what the US government has called patent intensive products. So that also means that if you're a startup and there's a patent or there's some technology involved, there's an opportunity to move that technology around, possibly to lower duties in some cases, or maybe to restructure it a little more easily so that the product could be deemed the origin of another country, perhaps still utilizing some of those Chinese parts or components.
I was gonna save this one for later, but I think you were begging the question. So, how do we do that? What are some of the? And we've spoken about this a little bit, but and you opened my eyes certainly, which I think we're heavily involved with. We have a team in China, and so I think this would be news. But what are some of those details? How can you legally, move the numbers around to make it work?
So, any disruption in a supply chain is going to be expensive and time-consuming and fraught, and it's not going to be permanent. Values change, the competitive nature of a particular market for manufacturing may change. So all of this, to a certain degree, you'll get more stability by leaving China, but you're not going to find 100% stability. You got to take that as a starter. Also, a lot of this is the domain of folks who people have not gone to for a lot of advice over the years. I mean, customs lawyers. I mean, when duty rates are 2%, yeah, that matters on average in the U.S. about 2%. But frankly, it's not typically the kiss of death. But when you start hitting 10, 25%, gee, this is real money involved. So all of a sudden, doctrines that people really have not visited for 20, 30, 40 years with China regarding when is a product made in China? How can I lower the duties? What happens if I process it elsewhere? What if I have a screwdriver operation in Taiwan or Mexico? What if I warehouse it someplace and then put some packaging on it? Does that make it made in that other country? What qualifies it to be made in another country? And if I have to export it to China because all the raw materials are there, all the knowledge is there, I'm not at a point in my product life cycle to move it on, what can I do in that situation to lower the tariff? So the first question is one that we call an issue of substantial transformation. And this concept, which came out of a case involving Anheuser-Busch about 110 years ago, is also embedded in WTO doctrine, although every country does it differently. And basically what you have to have is a product has to develop a different name, character, or use. The U.S. loves these vague concepts, of course. Name, first of all, forget about name. All because you rename it isn't going to mean that it's made in Taiwan. Because, I called it a widget in China, but I'm calling it a gidget in Taiwan. That's not going to work. Drop it, okay? Just like a screwdriver operation, that's not going to work either. Maybe jumping a tariff classification, a high-level tariff classification, that might help. That kind of naming might help. But we're really mostly talking about is the character of the product. Now, in some cases, it could have been something that you already sourced from outside of China that may actually be the defining aspect of that product. For example, a subdermal needle manufactured in Korea and Japan is assembled in China into final packaging where all the relevant materials are put there, and actually that needle is approved by the US FDA for surgical applications. Now there's a customs ruling on that product, before the trade war, is not a product of China. It's a product of Japan or Korea, because the needle is what defines the principal character of that object. So again, you're not necessarily looking at the place where the product is finally packaged, is where it's getting its fundamental name, character, or use, and forget about it. Okay, so that's one example. But what if you just have a very IP-intensive, high-tech intensive product? Well, in some cases, and there's a customs ruling on this as well, if you loaded the software into a particular product such that it developed a functionality that it didn't have previously, sometimes that can be enough for it to be deemed to have a different character or use. Sometimes, you got to be careful, sometimes also how you assemble the product. What if you do 3D manufacturing? If all the design work is done in the United States, that design work is not dutiable upon entry into the United States. So some of the new manufacturing techniques mean it could be easier in some cases to migrate that manufacturing to another place, or alternatively, reduce the valuation of the goods as they are exported from China. And by reducing the valuation, I mean that you're basically pulling out intangible aspects of the value that U.S. Customs will look at in assessing the duty. So if you can reduce the China value of a product by 50% and you have 25% duties, you've effectively reduced the duties to 12.5%. Half of what it would have been at 25. So there are ways of doing that. For example, sometimes if you pay royalties to a third party rather than to the manufacturer, it will no longer be included in the value of the product as it's entered into the United States. Generally, trademarks are not dutiable. They're not included in the value of the product. But design work, certain quality control done by the U.S., all of that can come off of the value, doesn't have to be charged by the manufacturer, and you can thereby lower the duty rate. So there are ways also of bringing those products out, sometimes by adjusting your royalty payments, your licensing schemes, to lower the duty rate, even if you're stuck with manufacturing in China, at least for the near term.
You know, I think as I've been pondering this question a bit, it seemed a lot of the interesting hardware that we do is based on microcontrollers and smart electronics, and certainly the software and firmware behind that. And I could see this almost actually backfiring a little bit if your chip is made in China and you try to then export that to Philippines or Taiwan and avoid this. And can you, because I see that maybe as being the low-hanging fruit potentially in our space, is that you have these very expensive electronics. And can you speak towards that a little bit? Would that microcontroller still be considered the key component of a
well, first of all, the definitive guidance is always going to come from U.S. Customs and a customs ruling. So, and there's a very thick volume you can find online where you'll find a lot of these country of origin determinations. They're very fact specific. I think there's a little bit of distrust that simply migrating intangible objects, but if it does acquire a new name, character, or use, then you're mostly there. There is this one ruling that was specifically that, where there was software, perhaps firmware, that was embedded into a chip and then packaged, and whatever the device was, it was deemed enough for it to be made in that second country. There's another thing also to keep in mind here, which is that in some cases there's a flip side doctrine where some companies are finding it's hard now, for example, they're concerned about selling to a Huawei or ZTE, they've been denying export. Sometimes they've been placed on an entity list and they're not supposed to acquire U.S. technology. There's a somewhat similar concept for export controls. That is, if a product comes from a country where there's a certain, at least 75% local value for export controls, it's deemed, if it's 75% of the technology comes from that country for an export control purpose, it's deemed a product of that country. So you could continue to sell. So Intel, for example, is selling high-end chips to Huawei out of Israel. Oddly, this really hurts the U.S., but they've said 25% of the technology is U.S. in origin, 75% Israel, wherever else. I'll continue selling that one. TSMC is also fabricating chips for Huawei on the same basis and calculated 25% value. So sometimes you could be caught in between the two, but that's something also to keep in mind.
All right. Well, that's great. I think, so definitely some options here, and a lot of details. So customs lawyers seem like they're going to make, there might be the big winners.
They should be very happy.
So Phil, getting back to you here, I think the theme of the administration where we're at right now is volatility. And as a startup, as we've heard from our panels earlier today, there's so many moving parts. As a startup with a small team, it's very hard to be, ironically, it's harder to be agile in hardware as a startup because you are dealing with so many different fires in a given day, and so having a volatile supply chain is really tricky. Do you have any suggestions on how you could set up the supply chain strategy in the current environment to help reduce some of that volatility?
So one thing to keep in mind is the extent to which China is just there, right? So if you look at some of your other options, right? You look at Thailand, you look at Vietnam, you look at India, things like that. If you look at the graphs of just like parts and components that are shipped back and forth, some of the data Mark was talking about, it's orders of magnitude greater for China. You actually have to take the graph, take the China line off, so that you can see all the wiggles in the other lines, because sometimes you're dealing with you have to do it 10, 20, 30 more times. So you have to bear in mind that China's there. So I suppose if you're just getting in at the beginning, it's one of these. It kind of reminds me of Jim Cramer's bit about bears make money, bulls make money, but pigs get slaughtered, right? You might have to think long and hard about, well, okay, do I want to get in on China now and deal with all these things, or do I want to avoid it entirely, right? That might be one approach. But another approach to think about is what started this fiasco, this trade war thing. And if we think back to what Mark said, what was it about, 15, 20 minutes ago, this is the idea of intellectual property, right? This battle over that. Might it be possible to actually turn the situation on its head? That is to say, use the cause of this problem, intellectual property, as actually a driver, as a solution, based on what China has in fact done, right? Because we have in fact seen China being a proactive player in this, right? China's not just sat back and said, well, this is the way it is. Laws have changed. Intellectual property tribunals have sprung up. Mark can talk in greater detail about some of these things, but intellectual property can actually be used in some very creative ways now, and so thinking about that. So I guess to sum up what I'm trying to say is, first of all, we have to think about that China's going to be there. It's orders of scale, order of magnitude greater. You're dealing with complex supply chains that are hard to unwind overnight. It's not like you're dealing with textiles, right? And even if you say, okay, well, I'm going to start assembling elsewhere, a lot of the parts may well still be sourced from China, right? So it's thinking about how China is going to be there. There is some hope if you look at the aggregate data that we have on various and sundry parts and components from different sectors. And remember, I said telecom, that's been hit pretty bad. It's like, woo, drives off a cliff, right? Office and communication kind of just it was doing okay, woo, ouch, right? But if you aggregate that with some other things like photography apparatus and things like that, some professional scientific equipment, if you aggregate all these things together, all these different parts and components, you see a lot of volatility in China in particular, but it's within a band. It's kind of like the currency. So in some ways, this reminds me of just dealing with China in general, right? There's always going to be that band in which things go, but in terms of thinking through that volatility, be willing to monitor the situation and not just believe everything you see or hear in the news, right? Look deeper, right? Use data, right? It is out there, and sometimes the data is good, sometimes the data is less good. But as a very wise man at the Berkeley Law School likes to say, in the land of the blind, the one-eyed person reigns supreme. So don't be afraid to bring data into play. Don't be afraid to keep up. Don't be afraid to keep up with current events and things of that nature. The changing regulatory dynamic. Because having worked at being a paralegal at a Chinese law firm, we had a lot of international clients that came in. And there tends to be this assumption, oh, China, it's just like communist country. That's not a thing. Right, but there's actually, in terms of corporate law, there are actually a lot of affinities with things that you're used to and things of that nature. So be open, have an open mind to that, and have an open mind to the fact that China is not static. In fact, it's one of the things that makes it so fun to study. People are like, "Why do you like studying China?" It's like, I don't know what's going to happen. It's dynamic, right? It's not like studying some other parts of the world that are more established. So I think this would be a good time to turn over to the IP lawyer and talk about some of how you can actually turn the situation on its head, right? If IP is the problem, how do you make it the solution?
That's a great segue. So let me just be a little disruptive for a moment. Well, first of all, let me ask you, how many of you have patents? How many of you have trademarks? How many of you have something of a trade secret or proprietary nature? Mostly everybody does, even I do. Okay, so for those of you who have patents, can you put your hands up again? Okay, I'm assuming those are all U.S. Keep them up for a second. Those are all U.S. patents. If they're not U.S. patents, put your hands down. Okay, so the ones who have, does anybody have Chinese patents here? Put your hands up. Two, okay. Even if it's being applied for, okay. Let me just throw some information out there, because I think that you probably need this even more looking at those hands. First of all, China's a hyper-patenting environment, okay? So we're looking at a situation today where if you took all the patent offices in the world, except China, and put them together, the number of patents would be less than those filed in China. Okay, that doesn't mean they're high quality, but it does mean they're being litigated. So if you took all the patent litigation filed in the U.S. last year, multiplied it, I would guess, by about 10 or so, you'd be at the level of Chinese patent litigation last year. Actually, the total volume of IP litigation, not including the administrative system, was 340,000 cases. In the U.S. last year, I suspect patent, trademark, copyright, trade secret cases didn't exceed 10,000. So it's probably around 30, 35 times the U.S. docket. This is a very explosive environment. It doesn't mean that IP rights have the same value there, but it does mean that if you don't have rights in China, for want of a better word, you're going to be screwed. The other thing is China also has inexpensive rights. So it's not like you're going to your US lawyer and he's drafting the claims, he's going to have several meetings with the patent office, he's going to have to fly down either to Washington DC or maybe the branch office in San Jose and have a lot of meetings and charge you $600 an hour. You can get a utility. When I was in private practice, I don't think my firm appreciated it, but I would often encourage smaller clients to get a utility model which will cost you $500 to $1,000. No examination, limited translation, it's a diagram. You'll get it in a matter of weeks, and you'll have something. It's good for 10 years, and actually has a high litigation value in China. So if you don't have those Chinese patents, think about it, because you're really quite exposed, and it's a high litigation environment. The other thing is if you have a product design, and you've gone to China to manufacture, maybe you've invested in the manufacturer or you're sourcing the goods, and there's probably some kind of a license agreement or something that should be called a license agreement that's going into that. Now, under former Chinese law, and this is until about March or April of this year, so we're looking at a period from January 1, 2002 until early 2019, when you transferred any form of technology to China, whether that was in the form of a licensing agreement, whether it was in the form of a joint R&D, whether it was in the form of localizing a product for the Chinese market, even if it was not for profit, the Chinese side owned all improvements to that technology. Notwithstanding anything you said in your agreement. Okay? So, don't be surprised, for those of you, almost all of you, who didn't raise your hand, when you didn't file a patent that the manufacturer in China did, and has acted like it has created that invention, and has put you in a position of risk. I'll give you an example about one patent holder you may have heard of, Uncle Sam. Uncle Sam does collaborative R&D with China. Over the past 10 years or so, about 530 patents were filed by the United States, by U.S. entities that had collaborated with Chinese entities, filed patents in the U.S. Patent Office. Initial research I did when I was in the government showed that there were about 10,000 patents filed by Chinese entities that had received those grants that were filed in China in the name of that Chinese entity itself, without indicating that there was a U.S. collaborator or U.S. government filing. I mentioned that China is a hyper-patenting environment. There's all sorts of reasons people file for patents. Some of them are frankly to get recognition from the local government, get a subsidy, be considered an innovative company. It's because the local mayor said, gee, I want you to file patents because I want to be recognized as innovative. There could be all sorts of reasons not related to asserting the patent. So don't go home at night and necessarily lose some sleep. But you have to realize you are in a highly competitive environment where the law supported the Chinese entity going ahead and filing for patents. Now, all of this and claiming rights in your invention, in your creation. This is an all too common scenario. Now, the law changed in March, and you're now free to negotiate what you want. So actually, this means it's a good time to go ahead and negotiate ownership of improvements to technology. And also, there was another provision that was an indemnity provision. A small startup company licenses technology to China to manufacture. Under Chinese law until March of last year, you were granting insurance to the Chinese company. If anything went wrong with that product, if they were sued, either because someone hurt themselves or because they were sued by a third party for infringement, you, the startup, were obligated to indemnify that Chinese entity. If you're all looking at me like kind of shocked, I've been giving this talk in the Bay Area for many years, and I would say that 99.9% of the lawyers even are unaware of this. But this is something called the Administration of Technology Import-Export Regulations. It's black letter law. It's non-negotiable. There's been very few cases, but because of that, I think there's an opportunity always to negotiate with China, even when the law seems unfavorable. but especially now that the law has changed. So how does this all work together? Think about it. IP-intensive goods, supply chain intensive goods, extended supply chains over multiple countries, a lot of volatility, unpredictable duty rates, duties that target these IP and supply chain intensive goods, and now a changed licensing environment. What that means is, hypothetically, you can go to your partner and say, you know what, I've been looking at the way we've been doing business. We've got to lower our duties. Furthermore, the environment in China has improved a lot on technology. I'd like to see what patents, if anything, you filed, if you've made any improvements, because I think I should own them. Or perhaps we should go to Vietnam or Thailand or India or Taiwan together and start manufacturing there, at least for the US market. And you have an opportunity because the environment in China has improved. And the licensing environment in particular has improved. And frankly, you have to think seriously about moving around those designs, that technology, that software, those patents, or acquiring them in order to minimize your duties, as I said earlier.
Very, very interesting. I would like to throw out there, there's patent protection, and then there's business reality. And marketing and selling these products is still a challenge. And we've shared over 1,000 designs with Chinese factories and have yet to see any competition in our marketplace. But we have had our customers knock them off. We've had Taiwanese factories knock them off. We've had American factories knock them off. So just want to kind of close out our discussion here with, IP strategy is really a part of business. It really needs to be integral to your business strategy. It's critical to know this information. You should be thinking about this as you're developing those relationships. But signing the right contract or understanding that the basis of IP law is only as good as it fits into your business strategy. Because we have a lot of conversations all the time about, well, I'm so concerned about the Chinese factories taking my product, but the reality is that they have a hard time competing usually in the markets where you're trying to sell. So if you're worried about them, you probably have bigger challenges that you should be first concerned about, making sure that the people that can actually really sell and market your product you're protected from them. But we've got a few more minutes, and I know we probably have some burning questions out there in the audience, so let's get them up here.
So you mentioned cross-border patent issues, and specifically the case where a Chinese company patents something that a U.S. company patents in America. So now you have two different companies patenting the same thing in two different countries, which are obviously subject to different patent laws and litigation issues. Am I to understand that the primary impact of this is that if you are the U.S. company manufacturing a product in China, that if China, if you don't have the Chinese patent and they, rip you off, the main impact is that you can't stop them in China from, going forth and manufacturing that product and trying to distribute it themselves, versus if you have the patent in China, you can at least try to litigate it under Chinese law and thereby prevent them from, copycatting.
So basically that's it. Let me add a few little embellishments. First of all, I'm trying to think in your shoes, and why the hell would I get a Chinese patent IP system sticks, right? That's a typical American reaction. So let me just do a little very brief data dump on you. As Phil mentioned, I like to deal with the data. You hear a lot of horror stories, and believe me, I'm not denying that any of them exist. There are a lot of horror stories. But on average, your likelihood of winning a patent dispute in China as a foreigner is higher than a Chinese winning a patent dispute in China, and is higher than you would be winning a patent dispute in the United States. Okay. So and I can pull out, if you give me 2 minutes of my phone, 5 recent academic articles using 5 different databases that show that the win rate on average is about 84%. In addition, there's no eBay doctrine, you will get an injunction. So if everybody's manufacturing those products in China, right, because you have competitors all over the world, they're all going to China to manufacture. You get that injunction, if they're infringing your patent, you stop the supply. Because it's a bottleneck. It's not like an injunction in Taiwan or India, wherever else, where there's going to be a thinner flow of supply. Damages are low, very low. Don't expect much from the damage side. It's all about the injunction. In addition, Chinese customs will seize goods on export. That's not required by the WTO, and they'll seize goods that infringe patents. That's also not required by the WTO, as well as trademarks and copyright. So the bottom line here, though, is this is a calculation of cost and benefit. And the important thing is, don't put on your American hat when you think of cost, and don't put on your American hat when you think of benefit. There are cheap rights to be obtained in China. They often have a high litigation value. And there are cheap procedures to do, like going to customs, recording your patents and trademarks and copyright, that can have a significant deterrent impact. The other thing to keep in mind is you look at, legal costs, is like, I often kind of have to gulp when I talk about litigation in China, because really a Chinese court case is really something different from an American court case. We take court cases really seriously. Company valuations live or die on major court cases. In China, your first instance court case is over in 6 months. Your appeal is over in 3. In the US, you haven't even completed discovery. Okay? So what is the typical play? I have to stand up because I talk about this all the time. And I get excited. So here's the typical play. You have a manufacturer in China. Relationship has gone south. You find out they have a ton of patents that they file on improvements to your technology that you're also using, okay? So what they do is, sue them in the United States because you don't want them selling their product into the US. US is your key market. What they do is they go ahead to a Chinese court after you've initiated your expensive lawsuit with your expensive downtown San Francisco law firm, and they go ahead and hire a local law firm in the local city where they manufacture, and they say, I want an injunction. Boom, 6 months, you're in jail. Oh, you appeal, 3 months, it's affirmed on appeal. You're not even over in your case in the United States yet. What do you get out of that? The Chinese company goes to you and says, you know what, you may have invented this, you may have raised a lot of money, you may even have certain markets, but you know what, I'll let you manufacture in China if you leave me completely free of any IP claims. And that's how you lose your hold over global markets. And don't think this is a problem for just little companies. This is all too common. This is how China leverages its domestic system. So what do you have in response to that? A lot of this stuff is cheap. Get those utility model patents. $1,000 a pop. Design patents. You can get a design patent in China in a matter of weeks. Sometimes days, I've heard. If it's in certain areas like lighting fixtures and furniture, they have super accelerated process, days to getting a design patent. Inexpensive, it gives you something to negotiate, something to assert. But this is actually a highly litigious environment. This is a highly opportunistic environment. And if you lose those commercial advantages, the ones that you specifically spoke, you may find that your former best friend is now the guy you're fighting, neck and neck with.
And just a super quick follow-up question. So I'm sure we're all wondering, if we wanted to pursue getting that Chinese patent, what is the first step of it? Do we need to talk to an IP lawyer? Or how do we go about that?
I train American IP lawyers all the time. I love them. I love my students. Most of the time, they don't want to give out the cheap advice. And every time you go to a U.S. lawyer to hire a Chinese lawyer, you got an intermediary at a very high billing rate in between. So, choosing the right lawyer in China and having one directly that you can use, I think a lot of American companies sometimes run astray. They're looking for the guy or a woman who speaks great English. She may not always be the best lawyer, but I think finding someone local that you trust is critical to an inexpensive IP program. I would also really encourage you to attend any of the free seminars that I started when I was back at the patent office. There's one coming up, I think November 20th or so in Washington, but they go around the country. We do these IP roadshows, mostly to reach out to startups and small companies about how to develop a cost-effective strategy. But finding a local lawyer, using rights like you look as a U.S. lawyer, filing a utility model patent, it doesn't get examined. It's just filing a piece of paper. So yeah, I'll charge you $1,000 or $2,000, but there's no follow-up work. It's not like filing a U.S. patent, $10, $20, $30, $40,000. So it's not something you're going to naturally suggest. Furthermore, they call them petty patents. What's the value? I'll tell you the value. The highest patent damages in Chinese history was for an unexamined utility model patent that was asserted against Schneider Electric, a company called Chint. It was 330 million RMB, so it was about $60 million. And it was a real wake-up call for Schneider, which said, patents in China, why should I bother? The next thing you know, there's a global cross-license, and Chint was all over the European market.
Oh, this is just amazing. So I'm not a lawyer, and so I'm a community builder whose job is to give you guys great information and connection. So I will make a shameless plug for Orsum, is the folks we've worked with a while, and they are on a total different scale of the cost. Right? They're local Shenzhen, and it is a very different perspective. So you really do need to look at it very differently. But there are good resources, of course. There's lots out there. There actually, a lot of these firms are speaking English more and more, and are more supportive. So the other one I just want to throw out there real quick is trademark. You can get a trademark in no time for I think about $180, and the exported goods from the ports now go through. I know we have to sign off paperwork that show that we are the owners, or our customers are the owners of the brand. And that's been happening for about 4 years now, and they are very strict on that. So a really great trick is to build in your tool your brand. So make sure it's in your injection molded or whatever tool you have.
And in Chinese and in English. Yeah. Both marks. They happen to speak Chinese in China. Very important.
And yeah, great point. But that's very easy to check. It's totally enforceable, and they do it like that. I mean, they do not waste any time. So there are some good tips and tricks out there. So I really want to thank you, Mark and Phil, for your time and your expertise.